Hello and welcome to the lecture for Chapter 4. This chapter deals with the legal liability that's associated with CPA firms performing audits. As we talked about in past lectures, a CPA is liable to people that rely upon the attestation that they provide for financial statements. So, meaning in common terms, they can be sued and lose. So we'll talk a little bit about the different types of liability that CPA firms are exposed to that exist both through common law and through statutory law. So we'll talk about both. We'll talk about proof requirements under both types of ways in which they could be sued. And then finally, I'll talk about the Security Acts of 1933 and 1934 and ways that CPA firms can limit their liability. So different types of liability. Oftentimes when a business fails and people have relied upon the financial statements to make decisions about either investing or lending money to that company, oftentimes the CPA is the last man standing, meaning they're the only one involved that has any money or potential insurance for people to get through a lawsuit. So there's very low risk for somebody to sue a CPA firm and a potential big reward. So think about the large number of parties. It's not only all of the people that are shareholders, it's all of the people that used to be shareholders and it's future shareholders that may have paid a price that was inappropriate based on now revised financial statements. So it's a really large pool of people that could potentially sue a CPA firm. So of course there is insurance to cover that risk, like there's insurance to cover any kind of risk, but they can be really expensive when you think about the size of the potential payouts. So it's difficult for a lot of firms to get that kind of insurance, so it can limit the number of firms or the types of firms that can perform audits, and it's led to a consolidation in the profession. There used to be 8 big accounting firms, and now there's 4, and a lot of small firms. For example, most of the firms in Olympia don't do audits for that reason. So sources of liability, you've probably in Business 225 learned about common law. That's the law that is based on precedent and prior cases and those sorts of things. So the types of common law that exist, one would be a breach of contract. So the client hires a CPA firm to do X, the CPA firm does not do X, or they do X with negligence. The client can sue in that case for that. Ordinary negligence is just a violation of duty of care. In the case of a CPA, it means that they didn't follow generally accepted auditing standards, or they didn't they allowed deviations from generally accepted accounting principles. Gross negligence would be a reckless disregard for their professional responsibilities, meaning they didn't bother to show up to view the inventory being counted, or they didn't bother to verify any accounts receivable balances when they were material. That would be kind of above and beyond ordinary negligence. Fraud is a bit higher bar. That's colluding with a client. So again, they could be sued for fraud under common law. Statutory liability is violating laws that have been passed, and there's 2 particular laws that we'll talk about later in this lecture. So I'll wait on that. So sources of CPA liability, the client has to prove the following. 1, that the CPAs accepted a duty of due professional care. That means they agreed to perform the engagement, and by agreeing to perform an engagement, they're also considered to have agreed to do a professional job at that. They have to prove that the CPA breached that duty through negligence, that they were supposed to do the job in a certain way and they didn't do that. They have to prove that the client suffered losses. So they can't just say we would have made more money had this been better. It's they actually had to have lost money. And the damages have to be caused by the CPA's negligent performance. So the damages can't be due to business conditions or something like that, or acts by a competitor. It has to be the damages were directly linked to the CPA's negligent performance. The burden of proof rests with the plaintiff. So the plaintiff has to prove these aspects. It's not up for the CPA to prove their innocence. Some of the defenses to negligent, one is, and the first is, that the accountant was not negligent. So the CPA could point to their working papers. If you go to work at an auditing firm and you engage in audits, you will get extensive training on how that firm organizes and documents things in their working papers. It's really important that that is followed and done, and a really good job is done in that regard, because that is going to be their primary evidence that they were not negligent. You could also defend yourself by saying that the negligent wasn't the proximate cause of the loss, that the loss was caused by something else, and that the negligence on the part of the accountant is an ancillary issue. Or you could claim that the client was also negligent. So that's contributory or comparative negligence. So maybe the client withheld information from the CPA, causing the CPA to do an inappropriate job. Well, then the burden rests with the client in that case if they had a share of the blame. It could result in a split judgment. So, for example, the bank suffers a loss because of improper financial statements, and it could be that the client has to pay some of that loss and the CPA firm has to pay some of the loss. So liability for fraud involves the following: a misrepresentation of a material fact. So receivables are reported at one level when they're really a much lower level, that sort of thing. So overstating net income, overstating assets, understating liabilities, all of those would be material facts that you misrepresent. It requires an intent to deceive. The book uses the word "scienter," and that is what that means, an intent to deceive. So it wasn't an honest mistake, it was a mistake made intentionally for some purpose. And that somebody justifiably relied on that misrepresentation to make a financial decision. To invest in stock, to lend money are the two most common. So there's two types of fraud. Actual fraud, which is what we just stated above. The CPA intentionally misstates a material fact and the client is injured as a result of relying on that fact. Constructive fraud means that the professional that the CPA was so grossly negligent, they lacked fraudulent intent, but they did such a bad job that they kind of put their seal of approval on the fraud and gave it a veneer of credibility. So potential liability to third parties, the book talks about three different cases that guide the law in this regard. And the one I want to focus on is the second of the three, because it's what's recognized in most states, including Washington. And that's the restatement of torts. So in the beginning, many years ago, accountants only owed a duty to their direct client, the person that hired them. That's called privity of contract. I can only be responsible to the person that I enter a contract with. So that was then opened up. So that would say only the client that hired you can sue you. Shareholders can't, banks can't, and so forth. Well, that's been expanded, of course, because other people then suffer damage as a result of relying on the CPA's work. So the restatement of torts states that the accountant is subject to liability for negligence not only to the client, but also to foreseen or known users of their reports or financial statements. So of course, in the act of completing an audit, they're going to know who the known users of the financial statements are, who the lenders are, and who the shareholders are. But it would also include foreseen. So what are some others that might be users of the financial statement? And that is fixed by the accountant's knowledge at the date the audit is published, not what they then learn at some later date. So you're responsible to all of those known and foreseen users of the financial statements. So these are the three approaches, and again, the middle one is the one that I want you to focus on. So the Security Acts of 1933, this is now we're talking about statutory liability. So the Securities Act of 1933 covers the registrants, which is companies that are registered with the SEC for their stock to be publicly traded. And in the act of filing a registration statement, that includes audited financial statements. So the Securities Act of 1933 is specifically written to cover the audited financial statements that accompany a registration statement. So we're talking about only initial public offerings of stock. So the CPA is required to do due diligence, and due diligence means not taking information from management at face value, but investigating it, okay? Kind of due professional care. Some of the defenses to this type of liability is, one, there weren't any misstatements or omissions, that is incorrect. You could argue about what the term material means in different circumstances. You could argue that the material error in the financial statements wasn't the cause of the client's loss, or that the client or the plaintiff knew of the misstatement but invested or anyways. So this is only, you're liable only to purchasers of the initial public offering of the stock, not to subsequent purchasers. So it's limited. The Securities Act of 1934 now covers subsequent financial filings. So publicly traded firms are required to file a 10Q, which is a quarterly financial statement, and they're required to file a 10K, which is the audited financial statement at year end. So those records then are used by subsequent shareholders. So a much larger group of people would have potential standing to sue under this law. So it wouldn't just be the holders of the initial public offering or the owners, but then subsequent owners as well. So it's a higher bar than the 1933 law, in that you have to ordinary negligence is not enough. You have to show that you had a scienter, that you had intent to defraud. So an accountant can avoid liability through a good faith defense, meaning they had no knowledge of the misstatement or omission and that they had no intent to deceive. So the liability was somewhat limited in 1995 to prevent frivolous lawsuits. So it requires auditors to use procedures to detect any illegal acts of the company being audited. It requires them to communicate with the company board of directors, the audit committee, or the SEC, and it establishes proportionate liability. So the CPA can't be left holding the bag completely. So criminal liability, an accountant can be found criminally liable, which means go to jail for violations of security laws and tax laws. So if they knowingly certify false reports, that's a criminal act. If they falsify, alter, or destroy accounting records, I had mentioned Arthur Andersen was the auditor for Enron. Arthur Andersen destroyed over 1 ton of company records. They were paid to destroy literally truckloads of accounting records for Enron, and people went to jail for that. Or obtaining property or credit through false financial statements. Those all provide criminal liability. And if you open the PowerPoint lecture and click on that blue link there, there's a short video of a CPA that talked about what had happened to her and how she went to jail for this exact kind of violation. I think you'll find it interesting. So confidentiality, we talked about this a little bit before. So communications between a CPA and their client are confidential, meaning you can't disclose that information to other third parties without permission, but they're not privileged, like communication with a defense lawyer would be, or communication with a doctor. So what that means is that a court could compel you to testify against your client and share information that you learned during an audit. That's what's meant by it not being privileged. You can't say you're not allowed to share that. You are under that. And that's the same case under Washington state law as well. So ways to limit liability, having a really strong emphasis on making sure that you comply with the letter of the law with regard to generally accepted auditing standards. Anytime you deviate from that, anytime you deviate from ethical requirements, for example, the rules that we talked about in the last chapter about independence, anytime you deviate from those things, you're exposing the firm to risk. Now, when you start an auditing job next year as a staff accountant somewhere, it's not going to be your responsibility to make sure that that's the case, but it's good to know that that's why a firm may be really, really strict about compliance with those things, because they're trying to protect themselves from suffering a lawsuit and losing. It's important to retain legal counsel that understands the specific nature of a CPA's legal liability. So a general purpose lawyer is not going to be able to do that. You need to find a lawyer that has that kind of expertise so that they can protect the firm properly and advise you properly. Have to make sure that you maintain an adequate level of liability insurance coverage. If you have $1 million liability insurance coverage to pay for claims that are brought against the firm for not doing a proper job with auditing, once you've paid out $1 million of claims, you no longer have that insurance. It's used up. So making sure that you have an adequate amount of insurance relative to the risks that you're taking on. It's importantly to thoroughly investigate prospective clients. Make sure that you avoid clients that are in any way connected with some kind of shady business or would represent an unacceptable level of risk to the company. Obtain a thorough knowledge of the client's business. That's important as well. It's important to use engagement letters. So when I've worked with auditing firms in the past, they've given me an engagement letter and they won't do any work or step foot on the property until the engagement letter is signed and returned to them. The reason they're doing that is they want to make sure that it is clearly delineated what my responsibilities as a client are and what the auditor's responsibilities are. And that's all spelled out in an engagement letter. You want to very carefully assess risks of error and fraud. So the key here, and we'll talk about this later in the semester, is looking at their internal control system, making sure that they have not only a well-designed internal control system, but make sure that it's being adhered to as well. You want to exercise extreme care in audits of clients that are in financial distress or in high-risk industries. So companies that have had a series of losses that may be kind of on the risk of losing their bank loan, that would be a client in financial distress. There's more likely to be inappropriate behavior or potentially fraud to avoid bankruptcy, that sort of thing. So those kind of clients represent a much higher level of risk than kind of a normal client. And then there's industries that are higher risk industries, industries that are more speculative in nature, and those sorts of things could tend to have more risk associated with them. And then key, this should be double underlined, bold, and in red. Maintain organized, comprehensive working papers. That is your #1 defense. So I appreciate you listening to this lecture. I will talk to you again when I lecture on Chapter 5. Thank you.